Good morning, good evening, good afternoon, and good night, wherever you are around the world. Today, I just want to ask everybody, when you come to this channel, please do me a favor, just press the like button and don't forget to subscribe. Today, we're going to talk about a little bit about Kelly, the call of Kelly's arrest. Let us listen to this, then I will take you somewhere. Let's listen.
When a court refers to the evidence which it has to evaluate, it means the totality of the evidence in question, not pick and choose, cherry pick. It means the total evidence. Like in this case, we've been sitting for about 3 years, and I'm told there are about 60,000 pages of evidence so far. So when this court talks about the evidence, so we're talking the composite tablets or tableau of all the evidence, because evidence is interlinked, and evidence sometimes can support other aspects of the plateau of evidence which encompasses evidence in a trial. Okay, sorry.
Inkosi enkantolo ikhuluma ke ngodaba lobufakazi nomfakazi okhona ke kule cala leli lapho ithi khona ke uma ngasikhuluma ngobufakazi okhona kule cala leli akumele ukuthi mhlawumbe lapho ke sicaphula mhlawumbe ikhethe ufakazi obuthile ke phothize engakhethi ke lapho athi na ke inkosi enkantolo lapho kukhuluma ngobufakazi bonkana obukhona futhi nalamakhasi ke awu 60,000 akhona ke obufakazi noma benkulumo nje sicelelwa ngaphambi kwenkosi enkantolo athi futhi siyazi ukuthi icala leli ke sele seliqeda ke isikhathi seminyaka emithathu lokho liqhamuka noma livela ngaphambi kwenkosi enkantolo mhlawumbe likhulunywa.
The state has preferred to charge all the accused before us by the invocation of common purpose and the alleged commission of all the charges with which the accused stand before this court. Consequently, it would be useful to grapple with what the state intends to put as a legal principle to be overcome by the accused. Common purpose, that is an act of one participant in causing of the death imputed as a matter of law to other participants, and the causal connection between the act of each participant in causing the death of the deceased need not be proved. If you invoke the concept of common purpose.
Manje ke inkosi enkantolo khuluma lapho ngenhloso ke evamile bathi ngesingisi common purpose athi uma ngabe abasolwa ke beke besenza into futhi beyiqembu mhlawumbe ezwene ukuthi bazoyenza ke lonto leyo ke athi lo kumele ukuthi lapho ke bayilethe mhlawumbe ethi ufakazi obambekayo mhlawumbe ufonele ubufakazi obambekayo phecelezi ngodaba lo lokho le common purpose mhlawumbe inhloso evamile athi uma ngabe mhlawumbe khona ke umsola oyedwa mhlawumbe abasolwa ababili abathathu beka ngaphezulu mhlawumbe uma sebala ngokuyibala lapho ke athi kepha kuma besenza ke into ngenhloso evamile akumele ukuthi ke oyedwa nawabo uma ngabe yenzile usho abanye nabo kade bengenalo ulwazi loludaba lolu.
I'm quoting from the case of S versus Ratha and others.
Family, I was mind boggled when I heard the judge quoting Sifata. You know, I was like, where is this judge going? When he quotes Sifata, when he was talking about the charges on common purpose for all the accused that are there, I just waited a little bit, but there's something that I noticed from Nisi. He was holding on his cheek. When he quoted that of Sifata, I saw Nisi looking at Sibanda and Baloy just a little bit. He just checked like that because I think he know that case law of Sifata. He looked at them a little bit. And I was like, why Mnisi is doing this? But little did I knew that he knew that what the judge was trying to say there. He was calling for Kelly to be arrested because they all acted in a common purpose. That is the charge. It doesn't matter whether you are in, he even quoted that it doesn't matter whether you're in England, whether you are where. But the fact that you participated in that conspiracy, then, you know, I laughed a little bit and I just said, what is this judge doing to Baloyi and brigadier GININDA? Because now Kelly has to be arrested. Listening to what Ratha has said, we know Rasta can say something today and then again the next day start to step back. But that is what he said. Let us listen to what Ratha said when he was calling for Kelly Kumalo to be arrested. Let's listen to this.
Appeal Division. Where it was stated that the principle applicable in cases of murder and its allied other charges, where there is shown to have been a common purpose, is that the act of one participant in causing the death of the deceased is imputed as a matter of law to the other participants, provided, of course, that the necessary mens rea is present. The learned judges are basically saying that, to make it ridiculous, if you participate in the conspiracy to realize or execute a crime which is in pursuance of common purpose, you need not necessarily be there. I heard one of my colleagues saying that when you go to Mgedeza, for instance, in Mgedeza they say you must be there. But that case of Mgedeza has limitations. Here they say if you are in concert with the persons who have planned and plotted, for instance, to murder a person by committing that offense, if you align yourself with that, you can be in England when they murder that person. You are also liable because you are part of the scheme. Okay?
Bese yabuya futhi kusenkantolo ecaphula kwecala lozombuso libhekene necala lapho-ke likaSifatha lango-1988 volume 1 SCA kade kuyaphila athi lapho-ke beyakhuluma pheqinga ngodaba lokuthi mhlawumbe uma besenza-ke into ngenhloso eyodwa-ke lapho-ke noma mhlawumbe ngokuzwana mhlawumbe nakhe kuzungu lapho-ke nenzeka into eyodwa futhi bese ngemuva ukuthi besenizwene-ke athi lapho-ke uma ngabe oyedwa lapho-ke enza into-ke phakathi nezwene niyithimba mhlawumbe ningabantu abaningi-ke lapho-ke kwamele ukuthi banithweseke amacala noma icala leli enibukene nalo lokuthi lokho nikuhlalele phansi bese nakuhlela engaphambi kokuthi nibulale. Athi futhi uma yenze sibukele lapho athi khona ke nicala likaMgedezi laba athi khona ke kepha kumele ukuthi ube khona ke phakathi kokulukuzana kufezekisa ilukuzana lapho ke inhloso evamile uma ngabe seleyenziwa kepha phela ukukhuluma futhi wayenza isibonelo so ukuthi uma ngabe nihlala phansi nihlela ekuthizeni kubulawe ke umuntu kepha ukuthi oyedwa khona ke lapho ke akekho la eNingizimu Afrika ke ungapheshwa kolwandle mhlawumbe kwizwe laseNgilani athi naloyo muntu kwamele ukuthi naye kathweswe icala lokuthi naye ubulele ngoba lokho kade lokuhlale phansi bekuhlelile njengethimba.
So this statement by the learned judges substantiates the concept of the applicability of common purpose, and hence they allege that a causal connection between the acts of every party to the common purpose and the death of the deceased need not be proved to sustain a conviction of murder in respect of each of the participants. Okay.
Wabuya futhi wakhuluma-ke lapho ngodaba lenhloso evamile ukuthi oyedwa noyedwa uma ngabe sele bekwenzile lokho thizeni bayibenze-ke inhloso evamile yokuthi babulale-ke umuntu lapho athi lokho akumele ukuthi balethe ufakazi ukubambe kahle ufakazi okukhona-ke kepha kwamele abasolwa-ke bathweswe icala ngodaba lokuthi yona benze into ngokuthi ade bezwene njengethimba ngaphansi kwenhloso evamile.
Okay, so a summary of the evidence which predicates this application has been prepared by the state in response to the allegations by Mr. Umalo on behalf of the accused four. I'm not going to dwell too long on the history of this case. It is trite and it is well known. And also, this application, it's a limited application. It's not an application based on the whole evidence. It's not. When I read it, it's limited. For instance, it is only limited in broad swaths and sweeps against Zungu to say that his evidence is fatally flawed. His evidence is contradictory and can't be relied upon, and his evidence is as good as non-existent. Nothing is said about other contentious issues. For instance, in this case, there was a ballistic evidence. 4 or 5 ballistic experts testified here in this court, amongst whom they were led by Mangani, Serrero, and the others. There was also here cell phone evidence, which was testified to by 3 or 4 experts, House, Stein, Pinky, Palinkim. Nothing is said about that evidence.
yabuya futhi inkosi enkantolo athi manje izokhuluma ngodaba lofakazi-ke obukhona kuleli cala leli athi lapho-ke khona kodaba lofakazi nje kuphela okhulunywa ngalo kathi ufakazi oyedwa athi uConstable Zungu-ke ukuthi ubufakazi bakhe buyafana nobufakazi ukuthi kade bufakazi obungekho-ke lapho-ke futhi kade bungahambisani ufakazi bakhe kuZungu futhi nabanye abufakazi. Kepha ibuya futhi inkosi enkantolo yakhuluma phecelezi ngodaba lobufakazi bama-ballistic report laba kwenziwa khona-ke iy'nhlolo zey'bhamu noma amabhulethi-ke noma iy'nhlamvu. Athi lapho khona-ke abufakazi kade beyifuna noma mhlawumbe abuchwepheshe abasebenza ngaphansi kwalo mkhakha lowo-ke athi kade bebane noma kade bebahlanu-ke abafika la ngaphambi kunkosi enkantolo-ke bethule bezokwethula ofakazi babo-ke athi ucaphule futhi amagama wabo mhlawumbe ukhulumile amagama abo athi khona kade khona-ke omunye phakathi kwabochwepheshe labo-ke uMangayi noSirero futhi nabanye-ke athi khona futhi udaba lwezocingo mhlawumbe abomakhalekhukhwini noma ubufakazi obalethwa balana ngaphambi kwinkosi enkantolo-ke ubuqukethe lapho noma ubuquka phakathi-ke udaba lwezocingo ke bathi ufalo babakaze kukhulunywe-ke ngabo lapho-ke bathi kade belethu lokozana uKellen Stein futhi nomunye-ke uHose futhi noPinky bathi kepha lobo bufakazi labo kwesicelo ngesikhathi sombuso lokozana ithimba labameli nokuthi noma-ke ummeli wakho belethe isicelo sakhe-ke akakhulumile ngalo daba lo. Kepha-ke thi inkosi enkantolo-ke futhi buningi ubufakazi obungakaze noma ongakhange bulethwe ngaphambi kusenkantolo mhlawumbe ukhulunywe ngabo kwisicelo lesi sakho.
And there's also evidence. You may term it confession evidence, or you may term it statements which were made by some of the colleagues of accused number 4. And was pointing out evidence. And there was a full, I think 4, 5 trials within a trials concerning the admissibility of that exigency of evidence, depending on whether it was pointing out or other aspects. For instance, this court ruled that that evidence, the aspect of the evidence in this trial should be placed on record, meaning it is still up to the accused to assail that evidence if they still believe that this court misdirected itself. But that evidence still exists and is on record. And I think I'm going to quote the case of Molimi, ne? Yeah, go on.
ithi inkosi enkantolo khona-ke obunye-ke ufakazi futhi nabo obukhona-ke obungakhulunyiwe ngabo lana ngaphambi konkosi enkantolo ngendaba ngesikhathi ekade lethwa-ke isicelo sakho yona-ke mhlola wesine-ke lapho-ke athi khona-ke iy'tatimende ezathathwa noma-ke ilokozana iy'tatimende zokuvuma-ke amacala lapho-ke bathi khona-ke la omunye ozakwenu akhulumile ngawe lapho-ke phakathi kodaba lolo ley'tatimende zokuvuma-ke amacala-ke athi lapho-ke khona-ke futhi into ebalulekile bengakazi bakhulume ngayo-ke lapho athi futhi athi khona-ke lapho-ke i-trial within a-trial mhlawumbe sithi uzicala noma umzila ngaphakathi komzila ngesikhathi lesi icala libehlelwe ngaphansi noma likhulunywa la ngaphambi kokusenkantolo-ke athi futhi-ke zonkani izitatimende lezo-ke futhi nokuthi yena hamba nawukhomba-ke lapho-ke nodaba futhi lokuthi kwahanjwa kwayokhomba suthi i-pointing out ngelumi lesingisi-ke bathi nalokho udaba lolo-ke likhona la ngaphambi kwenkosi enkantolo-ke sebelikhulumile mhlawumbe lifakile ngaphansi kwalokhu kade kushicilelwa kuhambisana futhi nodaba ley'tatimende zokuvuma-ke amacala.
Case of Key. This is Attorney General of the Transvaal. Krikla at the Constitutional Court surmised that in South Africa, despite of the fact that we have a constitution which guarantees rights to a fair trial in terms of Section 35 of the Constitution, there remains still a tension in our law, whether, even though the dictates of our law state that generally, if evidence has been acquired unlawfully, unconstitutionally, it shouldn't form part of legal proceedings in our country. And Krikla says, because of this tension in our country, that sometimes, even if evidence is acquired, collected unlawfully, it may be in the interest of justice to do that and to make this evidence applicable in our jurisprudence. Consequently, we all know that there's a concept which says a court may sometimes admit evidence in the interests of justice, despite the fact that it was acquired unlawfully and unconstitutionally.
Obiafuthi caphuna-ke kwelinye-ke icala selahlalela lapho lezombuso-ke libhekene icala likaKrikla lathi khona-ke bekhuluma khona-ke ngokuthi icala labantu kumele lihlalelwe phansi ngendlela ekhethekile futhi ngendlela ejwayelekile futhi nangokushesha-ke lapho-ke ukuthi futhi amalungelo abantu lapho-ke bangawashayi ngondiva-ke amalungelo abantu abala ngaphansi kwezomthetho kwesigaba saka-section 35 noma isigaba saka-35 sezomthetho-ke kulanayiningizimu Afrika-ke laba futhi akukhuluma khona-ke ngokuthi-ke uma ngasesibuka lapho ngaphansi kobulungiswa bezomthetho-ke uma bekhona-ke inkulumo-ke yabasolwa eyathathwa mhlawumbe iy'tatimende zabasolwa ezathathwa ngendlela-ke engekho semthethweni noma ngongemthetho-ke kwamele ukuthi lokho-ke bakuthathele emahlombe futhi bathathele elokuzana phambili-ke elithizeni lokho-ke inkosi enkantolo-ke ekwamukele-ke mhlawumbe iy'tatimende lezo-ke ezamukele ngenhloso yobulungiswa noma ngenxa yesizathu sobulungiswa bezomthetho.
It was argued correctly so by accused number 4's counsel that Zungu was a single witness, but then the problem which is outed by counsel is that because he's a single witness, despite the fact that the court is enjoined to examine and evaluate his evidence to see whether his evidence is as a single witness. Is found to be materially sound. And that if that is the case, obviously the question is, what will the court do about that? If it is sound and satisfactory in all respects, and consequently also it is material. Evidence must be material in order to be sound in all material respects. If you analyze Zungu's evidence, he says he was invited by a gentleman called Gwabeni to come to a celebration at Masutu Hostel. Because they will be having a party where there will be homeboys and they'll be celebrating, having eats and alcohol. And he duly arrived between 2 and 3 in that particular Saturday on the 26th of October 2014. And he says he was introduced to some of his homeboys. There were several of them there. Some he had met when he was still quartered in the rural areas. But subsequently he became a policeman, he came to Joburg. He lost touch with them. And this evidence is that as a result, Gwabeni had to remind him, this is Ratha, this is Mnisi, this is Baloi, this is Buthelezi. And he's excoriated for undertaking that trip, that memory trip with Gwabeni. I don't find it startling to be reintroduced to a person I last saw 10 years back. Some of them he remembered their names, some of them he did not. But what is critical and material for the evidence, as it will show later maybe when other evidence is being led, is that he says at that confabulation he met or saw accused number 1, number 2, number 3, number 4, number 5. Saw them and met them and engaged them and spoke to them. And even went to buy alcohol with them at Tops's bottle store.
Family, what do you think about what Ratha just did, calling for Kelly Khumalo to be arrested? Do you agree with what Ratha has just done there? Because none of the state pick their face when he said this. They all face down, they continue with what they were doing, they were writing whatever they were writing. But there's one person that I noticed when he said this, or two people I noticed when he said this. It was Linda Mnisi behind Mnisi. The eye that he used looking at Ratha when he said that, I was surprised. Like, you know, I just asked myself, why Mnisi just look at his colleague next to him, which is Sibanda and Baloi. This doesn't look good for Kelly Khumalo, because now it's up to the defense to capitalize on that, because there's no way they cannot capitalize on that. They need to capitalize on that until Kelly Khumalo is brought to justice, because Kelly was in the house. Kelly knows exactly what happened. There is no way that Kelly doesn't know what really happened when SENZO MEYIWA's life was deleted. So what the judge has just done there it brings a million questions. I hope if Kelly was watching at this during the 174 judgment, she should be shivering wherever she is as to what was the judge trying to do. Why did he do this? Another thing that brought me to little bit doubt what Ratha was doing. When he trusts everything that Zongo said there, we know that Kwaben is the one who invited Zongo. So whatever, if that is a fact, but I think when Absalom Zongo is called to the talk, we'll dispute this. Because it might not be the same day that Kwabeni called Zongo to come, Constable Zongo to come, or it might be something else. But to me, or my own opinion, because when the judge say Zongo evidence he found to be sound in all respect, what kind of what exactly he means when he says Zongo's evidence he found it sound in all respects? There's something that is wrong, and I don't believe that, because as much as in the application of Advocate Ngumalo doing it for accused number 4, he did poke holes on that evidence of Constable Zongo, but the judge tend to find that evidence sound in all respects. I don't know. I don't know. My law is a strict law, but even if I have a little bit of understanding things, not in this way. As much as most of us has been following this case, we understand exactly what was happening in this case. And for somebody to come and say Zongo's evidence is sound in all respect, I don't agree with that. I tend to differ with that opinion of the judge, but he might be saying it in some kind of respect how he came about with that. But as for me, I disagree with that, because I followed the case. There's a lot of loopholes that the judge has done here. Some, it's not even evidence that has been in that court, that he was bringing it up in that court when he was delivering the judgment. For example, talking about the cell phone that was found next to Basoto Hostel, which is, it was 463 meters away from there. That was new evidence, and it's not the only new evidence, because there's none evidence that is in that in all respects, but there's no evidence like that was ever produced in that court. But he gave his judgment quoting things that are not there. It's not the only one that he quoted. There's so many. So that's why we have a question with the judge whether in that cup something was there that maybe confused him, or he was under pressure, or at some point he did write his judgment, but because kunabantu esinye isikhathi abacontrolayo babuye bathatha lento bayidabula bathi wena uzawufika uthi laphana, hayi ngemali yethu sikunikeze yona ukuthi uzodlala manje la. No, there's some kind of things allegedly, but at some point you just bug your mind when you look at people who we think they are educated, are trained on law, and we expect them to deliver justice. But when you see this kind of behavior in court, you tend to ask yourself, is education still, or profession, is it still something that can help or that people can rely on, when we see people who we think have got this kind of education trained and they tend to do things the opposite way? So we really at times do not know who to trust, because at times money, they say, is power. Without money, you are powerless. So what do you think, family? Drop your comment. Don't forget to like, share, and subscribe. Bravo, bravo, bravo.